Imagine losing everything. Your business collapses, your investments go sour, creditors are circling, and you have absolutely no legal mechanism, no system, no court, no protection of any kind to help you start over. No Chapter 7, no Chapter 11, no discharge of debts, nothing. Instead, what you get is a jail cell. Or worse, your body literally handed over to the person you owe money to. That was the reality in America for the vast majority of its history. And what's even more shocking is that this wasn't some relic of the colonial period. For the first 110 years after the Constitution was ratified, the United States had a functioning federal bankruptcy law for a combined total of only 16 years. Let that sink in. 16 years out of 110. The rest of the time, if you couldn't pay your debts, you were at the mercy of state laws that ranged from humiliating to physically brutal to downright medieval. This is the story of what happened in America when you couldn't pay, long before bankruptcy became a permanent legal right. And trust me, it's darker than you think. Now, before we get into the American story, we need to understand where this whole idea of punishing debtors came from. Because the founding fathers didn't invent these laws. They inherited them. And the roots go deep, all the way back to the ancient world. In ancient Greece, if you owed someone money and couldn't pay it back, you didn't just get a sternly worded letter. You and your entire family, your wife, your children, even your servants, could be forced into what was called debt slavery. You would physically belong to the person you owed money to. You would work their land, you would serve in their household, and you would keep doing so until the creditor decided that your labor had covered what you owed. Some city-states capped this at 5 years and gave debt slaves certain protections that regular slaves didn't have. But make no mistake, your freedom was gone. You were property. Now, this eventually became such a widespread problem in Athens that by the 6th century BCE, a statesman named Solon came to power and enacted sweeping reforms. He canceled all existing debts. He freed everyone who had been enslaved because of their debts, and he banned the practice of debt slavery going forward. It was revolutionary, but it was the exception, not the rule. In ancient Rome, things were arguably even worse. The early Roman legal code, the 12 Tables, written around 450 BCE, gave creditors extraordinary power over people who couldn't pay. A creditor could haul a debtor before a magistrate. If the debtor couldn't settle up, the creditor could literally chain them up and hold them in their own private prison for 60 days. During that time, the debtor would be brought out to the marketplace on 3 consecutive market days, and their debt would be publicly announced. If nobody came forward to pay it, the creditor could sell the debtor into slavery across the Tiber River, outside Roman territory. And here's the part that sounds like it can't possibly be true, but apparently was. If multiple creditors were owed money, Roman law technically allowed them to divide the debtor's body among themselves. Now, historians debate whether this was ever actually carried out, or whether it was more of a legal threat designed to terrify people into paying. But the fact that it existed in the written law tells you everything about how the ancient world viewed people who couldn't honor their financial obligations. You weren't a victim of bad luck. You were a criminal, a cheat, and your body was collateral. Now, it's important to understand that in Rome, debt wasn't just a financial issue. It was a social weapon. Wealthy patricians used lending as a tool of control over the plebeian class. You'd borrow money to buy seed for your farm or to get through a lean winter, and if you couldn't pay it back, your creditor could effectively own you. The entire system was rigged to keep poor people dependent on rich people. And the legal apparatus, the courts, the magistrates, the law itself existed primarily to enforce the rights of creditors, not to protect debtors. Eventually, popular pressure forced Rome to move away from these extreme punishments. Debt bondage was formally abolished around 326 BCE after widespread unrest among the lower classes. But the underlying philosophy, the idea that a debtor was essentially a thief who had stolen from their creditor, that concept persisted for centuries. It traveled through medieval Europe. It was baked into English common law, and eventually it crossed the Atlantic. Now fast forward to medieval Europe, and the situation hadn't improved much. In fact, in some ways, it had gotten worse. The word bankruptcy itself comes from this era. In medieval Italy, money changers and bankers conducted their business on benches in public marketplaces. When one of these bankers couldn't meet his obligations, his bench would be physically broken in front of the crowd. Banco Rotto, broken bench. It was a public humiliation ritual, a declaration that you were finished, that nobody should trust you with their money ever again. And in some parts of northern Italy, the ritual went even further. A bankrupt person would be forced to strip down and in front of a jeering crowd strike their bare backside against a stone 3 times while shouting, "I declare bankruptcy." I mean, this was designed to degrade you completely, to strip away not just your wealth, but your dignity. In England, things took a more institutional form. When Henry IV passed the first formal bankruptcy statute in 1542, it wasn't designed to help debtors get back on their feet. It was designed to punish them. A bankrupt individual was treated as a criminal, full stop. If you couldn't pay, you were thrown into a debtor's prison. These were not pleasant places. London alone had dozens of them. The Marshalsea, Fleet Prison, King's Bench. These became notorious, and yet the conditions inside were horrifying. They were overcrowded. Disease was rampant. Typhus killed inmates regularly. And here's the cruel paradox at the heart of the whole system. You were imprisoned because you couldn't pay your debts, but you were also required to pay for your own imprisonment. You had to pay the jailer for food. You had to pay to have your shackles removed. If you had enough money, you could buy yourself slightly better accommodations within the prison. But if you were truly destitute, you'd be thrown into the worst section, where inmates were packed together with no sanitation, no heat, and barely any food. You were being punished for being broke, and the punishment itself required money. It was a death trap designed to look like justice. By the time England began establishing colonies in North America, this system of debtor imprisonment was deeply embedded in the legal culture. And the colonists brought it with them, stitch by stitch, iron bar by iron bar. Now here's where things get really interesting, because the American colonies weren't just populated by religious pilgrims and adventurers looking for a fresh start. A massive number of the earliest European arrivals were debtors. Some estimates suggest that as many as 2 out of every 3 Europeans who came to the American colonies in the 17th and 18th centuries were already in debt the moment they set foot on shore. Many of them came as indentured servants. They signed contracts agreeing to work for free, sometimes for 4, 5, 7 years, in exchange for their passage across the ocean and the cancellation of their debts. These contracts were essentially a commodified form of human labor. You were bought and sold. Your contract could be traded to another master without your consent. You couldn't marry without permission. You could be physically punished. And if you were a woman, the situation was even grimmer. Because if your master assaulted you and children resulted, your term of service could be extended by 2 additional years. This wasn't some obscure footnote in American history. It was foundational. The colony of Georgia was literally established as a haven for British debtors. James Oglethorpe, who founded the colony in 1733, had watched friends die in debtors' prisons back in England. He lobbied Parliament for permission to create a new settlement where England's imprisoned poor could start over. The irony, of course, is that within a generation, Georgia had evolved into a slave colony, and debtors' prisons existed there too. Now, the earliest known debtors' prison in the American colonies dates back to 1678 in Salem, Massachusetts. And from that point on, debtor imprisonment became commonplace across the colonies and then across the newly formed states. The conditions mirrored what you'd find in England: overcrowded, filthy, disease-ridden, and stratified by wealth. If you're a debtor from a higher social class, you might get a private room, you might be allowed visitors, you might even conduct some limited business from inside the prison. But if you were poor, truly poor, you were crammed into cells with criminals, and your prospects of ever getting out were bleak, and the amounts that could land you in prison were staggeringly small. There are records of people being imprisoned for debts as tiny as 60 cents. One case recorded a person locked up for a debt of $1.68. These weren't massive commercial failures. These were ordinary people who fell behind on a bill or couldn't pay a small loan, and the system swallowed them whole. Now, you might think that at least the rich and powerful were immune from all of this, but they weren't. And no story illustrates the absurdity of the system more than what happened to Robert Morris. Robert Morris was one of the most important figures in American history. He was one of only two people to sign all three of the nation's founding documents: the Declaration of Independence, the Articles of Confederation, and the Constitution. During the Revolutionary War, when the Continental Army was starving and freezing at Valley Forge, when George Washington had no money and no way to supply his troops, Robert Morris stepped in. He loaned $10,000 of his own money to the government. He personally financed the Yorktown campaign, putting up $1.4 million of his own wealth. He organized the first government-chartered bank in the United States. George Washington lived in Morris's house during two presidential terms. This man quite literally bankrolled the birth of a nation, and then he went broke. After the war, Morris threw himself into land speculation. He bought enormous tracts of land across western New York and in the new capital city of Washington, D.C., betting that post-war expansion would drive prices sky high. But the expansion didn't come fast enough. The Panic of 1796, a financial crisis triggered by land speculation and disrupted European trade, wiped him out. By 1798, Morris owed nearly $3 million, an almost incomprehensible sum at that time. He tried to evade arrest by hiding at his country estate outside Philadelphia for months, but eventually his creditors caught up with him. He was arrested and confined to the Prune Street debtors prison in Philadelphia. The man who had financed the American Revolution was now sitting in a cell, unable to pay his way out. Morris spent 3 1/2 years behind bars. His health deteriorated, his spirit broke. He was only released in 1801 after Congress finally passed the Bankruptcy Act of 1800, which allowed him to discharge his debts. He spent his remaining years in a modest Philadelphia house, living off a small stipend, a shell of the man he'd once been. He died on May 8, 1806, nearly penniless. A founding father rotting in obscurity because the country he helped create had no system for dealing with people who couldn't pay their bills. And Morris wasn't the only prominent figure to suffer this fate. Thomas Jefferson died in 1826 with roughly $107,000 in outstanding debts. Blair McClenachan, one of Philadelphia's wealthiest bankers and a member of Congress, spent time in a debtor's prison. The system didn't care who you were. If you owed money and couldn't pay, you were going in. Now here's the thing that makes this entire story even more maddening. The framers of the Constitution saw this coming. They knew that a functioning commercial republic needed a uniform system for dealing with insolvency. Article 1, Section 8, Clause 4 of the Constitution explicitly gives Congress the power to establish uniform laws on the subject of bankruptcies throughout the United States. The founders wrote it right there in the foundational document. They handed Congress the tool, and Congress for over a century repeatedly refused to use it in any lasting way. The first federal bankruptcy law wasn't passed until 1800, more than a decade after the Constitution was ratified. And it came only because the financial panics of 1792 and 1797 had thrown thousands of people into debtors' prisons and brought the commercial system to its knees. This first law, the Bankruptcy Act of 1800, was modeled after English practice. It only covered merchants, bankers, and brokers, not ordinary people. And it only allowed involuntary bankruptcy, meaning creditors had to initiate the process. A debtor couldn't voluntarily file for protection. The law was supposed to last for 5 years, but it proved so unpopular, so expensive to administer, and so rife with abuse that Congress repealed it after just 3 years in 1803. And just like that, America had no federal bankruptcy law again. For nearly 4 decades after that, nothing. The states were left to manage debtor-creditor relations on their own, and the patchwork of state laws that emerged was wildly inconsistent. Some states were slightly more lenient than others. Some allowed debtors to take a poor man's oath, essentially swearing that they owned nothing of value, which could sometimes get them released from prison. But the protections were minimal and unreliable. Then came the Panic of 1837. It was a catastrophic financial collapse triggered by speculative lending, crop failures, and the burst of a land bubble. Banks failed by the hundreds. Businesses went under. Unemployment soared. And once again, people who couldn't pay their debts were dragged into the system. The pressure on Congress to act became unbearable. And in 1841, they passed a second federal bankruptcy law. This one was actually groundbreaking in several ways. For the first time, it allowed voluntary bankruptcy. Debtors could file on their own, and it covered everyone, not just merchants and traders. Any person could seek relief. It was in many ways the first modern bankruptcy law in American history. But the political backlash was swift and brutal. Southern representatives who favored localized agrarian economies and saw federal bankruptcy law as a tool of Northern commercial interests fought it viciously. The law was also expensive to administer and generated enormous frustration among creditors who felt that debtors were gaming the system. Congress repealed it in 1843, just 2 years after it was passed. And so America went dark again. No federal bankruptcy law for 24 years. Now, during these long stretches without a federal law, the consequences for ordinary Americans were severe. If you couldn't pay your debts, your fate depended entirely on what state you lived in. And some states were nothing short of barbaric. In Pennsylvania, debtors who filed for relief could be publicly flogged. They could be subjected to having their ear nailed to a pillory post or outright cut off. And in one of the most grotesque carryovers from English law, some bankruptcy petitioners in Pennsylvania were branded on the thumb with the letter T for thief. Imagine that. You lose your business, you fall behind on your obligations, and the state burns a mark into your skin to ensure that no one will ever lend to you again. This wasn't the Middle Ages. This was happening in the United States of America in the same century that the country was building railroads and dreaming of manifest destiny. Even in states that had formally abolished debtors' prisons, the practical reality for people who owed money was grim. Creditors could seize your property. They could garnish your wages. They could take your tools, your livestock, your home. There were few exemptions protecting a debtor's basic necessities. If a creditor wanted to pursue you, the legal system was entirely on their side. And because there was no mechanism for discharging debts, no way to legally wipe the slate clean, a person could be pursued by creditors for the rest of their life. You could never truly escape. The debt followed you like a shadow. It's worth pausing here to note the federal government's own role in shifting the culture around debtors' prisons. In 1833, Congress passed a law abolishing imprisonment for debt at the federal level. And over the following decades, most states followed suit. By the mid-1800s, debtors' prisons were formally abolished in most of the country. This was a significant step, but it didn't solve the underlying problem. Because without a bankruptcy system, getting out of prison didn't mean getting out of debt. It just meant you were poor and free instead of poor and incarcerated. The debt remained. The creditors remained. The legal machinery of collection remained. You could lose everything you owned and still owe every penny. The Civil War made things even worse. The financial devastation of the conflict, particularly in the South, but also among northern merchants whose trade networks were disrupted, created a massive wave of insolvency. Congress responded in 1867 with a third attempt at a federal bankruptcy law. This one was more comprehensive than its predecessors. It allowed both voluntary and involuntary bankruptcy for individuals and businesses. It introduced new mechanisms for distributing a debtor's assets among creditors. And for the first time, it included provisions for corporate bankruptcies. But once again, the law couldn't survive the politics. It was expensive. It was complex. Critics said it was being abused by debtors who weren't really insolvent, just looking for a way to weasel out of legitimate obligations. After being amended several times, Congress repealed the law in 1878, just 11 years after it was passed. And so, for the fourth time in the nation's history, America found itself without a federal bankruptcy system. Creditors and debtors were thrown back into the chaotic patchwork of state laws with all the inequities and brutalities that entailed. Now think about what this meant in practical terms. The United States was in the middle of the most explosive period of industrial growth in its history. The Gilded Age was in full swing. Railroads were stretching across the continent. Factories were rising in every major city. New industries were being born. Fortunes were being made. And the entire economy was powered by credit. Farmers borrowed to buy land and equipment. Manufacturers borrowed to build factories. Railroads borrowed to lay track. The entire engine of American capitalism ran on debt. And yet there was no federal mechanism for dealing with the inevitable failures that the system produced. It was like building a massive skyscraper with no fire exits. Everything was fine as long as nothing went wrong. But when things went wrong, and they always do, there was nowhere to go. Now let me paint you a picture of what this actually looked like for the average person during this period. It's the late 1880s. You're a farmer in Kansas. You've borrowed money to buy seed, to purchase equipment, to keep your family fed through a bad growing season. Maybe you've mortgaged your land to finance improvements. The railroads have been promising that expansion will bring prosperity to the plains, and for a while it does. Prices are decent. You can make your payments. Life is hard but manageable. Then the bottom falls out. Crop prices collapse. A drought kills half your harvest. The railroads, which you depend on to get your grain to market, raise their shipping rates because they're in financial trouble themselves. Your creditors, the banks, the equipment dealers, the feed suppliers, they start calling in their loans, and you have nothing left to give them. In a modern system, you would file for bankruptcy. Your debts would be restructured or discharged. You'd lose some assets, but you'd have a path forward. In the America of the 1880s, you have no such path. The bank takes your land, the equipment dealer takes your tools, the courts allow your wages to be garnished, and because the debt can never be formally discharged, you can never fully recover. You're trapped in a cycle of poverty that you can't escape because the system offers no exit. Multiply that story by hundreds of thousands, and you will begin to understand the pressure that was building in American society by the early 1890s. Farmers, laborers, small business owners, they were all being crushed under the weight of debts they couldn't pay in a system that offered them no relief. This frustration fueled the populist movement. It drove calls for monetary reform, particularly the push for silver coinage, which farmers believed would inflate the money supply and make it easier to pay off debts. It stoked deep anger at the banks, the railroads, and the political establishment that seemed to care more about the interests of creditors than the suffering of ordinary people. And then came the catastrophe that finally broke the dam, the Panic of 1893. It began in February of that year when the Philadelphia and Reading Railroad declared bankruptcy. This sent a shockwave through the financial markets. For decades, American railroads had been laying track far beyond what the market could support, financing their expansion with enormous amounts of debt. When one of the largest railroad systems in the country went under, investors panicked. They started selling off their stocks and bonds. European investors, who had poured money into American securities, began pulling their capital out of the country and demanding gold in return. The United States Treasury's gold reserves, which were legally required to stay above $100 million, fell below that threshold. The panic spread from Wall Street to Main Street. Banks failed by the hundreds. Over 500 of them closed their doors. More than 15,000 businesses went bankrupt. 156 railroads entered receivership. Unemployment in some cities reached 25%. Nearly a quarter of all railroad track mileage in the country was under some form of bankruptcy protection. Tens of thousands of families lost their homes and savings. It was the worst economic crisis in American history up to that point, and its severity would not be surpassed until the Great Depression, 4 decades later. Farmers were decimated. Agricultural commodity prices, which had already been declining for years because of overproduction and international competition from countries like Argentina and Australia, fell to levels that made it impossible for most family farms to survive. Industrial workers were thrown into the streets. Factory after factory shut down. Small merchants who had extended credit to their customers now found themselves unable to collect, and their own creditors were bearing down on them in turn. In cities like Chicago, Detroit, and Pittsburgh, unemployed men lined up at soup kitchens and slept in doorways. Coxey's Army, a protest march of unemployed workers, walked all the way from Ohio to Washington, D.C. in 1894 to demand that the federal government create jobs. They were met with arrest. The human suffering was staggering, and there was once again no federal bankruptcy system in place to manage the fallout. The railroads, the largest sector of the economy, at least had access to what were called equity receiverships, a form of court-supervised restructuring handled by federal judges sitting in equity. But ordinary people, farmers, shopkeepers, wage earners, they had nothing. No protection, no mechanism for relief, no way to discharge their debts and start over. They were simply left to drown. The Depression dragged on for years. It reshaped American politics. It helped elect William McKinley to the presidency in 1896, defeating William Jennings Bryan and his populist crusade for silver coinage. And it created, at long last, the political will for a permanent bankruptcy system. On July 1st, 1898, President McKinley signed the Bankruptcy Act of 1898 into law, known as the Nelson Act after Senator Newton Nelson of Minnesota, who championed it. This was the legislation that finally stuck. Unlike its three short-lived predecessors, this law would remain in force with amendments for 80 years until Congress replaced it with a comprehensive new law in 1978. For the first time in American history, there was a permanent uniform federal system for dealing with insolvency. The law established the U.S. district courts as courts of bankruptcy and gave them original jurisdiction over all bankruptcy matters. It created the position of referee in bankruptcy, an official appointed by the court to handle the day-to-day administration of cases. It allowed both individuals and businesses to file for bankruptcy protection. And crucially, for the first time, it gave companies the option of being protected from their creditors, a concept that would eventually evolve into the corporate reorganization provisions that we now know as Chapter 11. But here's what I think is the most important thing about the Bankruptcy Act of 1898, and it's something that often gets overlooked. The law represented a fundamental shift in how American society thought about debt and failure. For most of the nation's history, going back through English common law, through medieval European practice, all the way to ancient Rome and Greece, the dominant view was that a debtor was a wrongdoer. Someone who owed money and couldn't pay was morally defective, lazy, irresponsible, possibly criminal. The system was designed to punish, to humiliate, to coerce payment through suffering. That's why debtors were imprisoned. That's why they were branded. That's why their families were separated and their property seized without mercy. The 1898 law didn't completely erase that mentality, but it began to replace it with something different. The idea that honest financial failure is not a crime, that an economy built on risk, on entrepreneurship, on speculation and investment and commerce will inevitably produce people who take risks that don't pay off, and that a healthy economy needs a mechanism for those people to get back on their feet, to start over, to contribute again, rather than being permanently destroyed and becoming a burden on the society that punished them. Now, this shift didn't happen overnight, and it didn't happen in a vacuum. It was driven by decades of economic devastation, by the suffering of millions of farmers and workers and small business owners who had been chewed up by a system that offered them no way out, by the manifest absurdity of a nation that prided itself on freedom and opportunity while imprisoning people for debts of 60 cents, and by the growing recognition among legislators, judges, economists, and the public alike that the old punitive approach wasn't just cruel, it was economically stupid. Locking a productive person in a cell because they owed money didn't recover the debt. It destroyed whatever remaining capacity that person had to earn and to pay. It turned potential contributors into permanent dependents. It was a system that ate its own. The irony of all this is that the Bankruptcy Act of 1898, this landmark legislation that fundamentally changed the relationship between debtors and creditors in America, was passed almost as an afterthought. The economy was already recovering from the Depression by the time McKinley signed it. The political energy that had driven calls for reform was dissipating. The bill itself passed with relatively narrow margins, 158 to 125 in the House and 43 to 13 in the Senate. It wasn't a grand moment of national reckoning. It was more of a quiet acknowledgement that the country couldn't keep lurching from crisis to crisis without a permanent system in place. But what it set in motion was enormous. The 1898 law was the foundation on which all of modern American bankruptcy law was built. The corporate reorganization provisions that emerged from the Great Depression era, the consumer bankruptcy protections of the 1978 Bankruptcy Reform Act, the Chapter 7 and Chapter 13 filings that millions of Americans use every year. All of it traces back to that moment in 1898 when Congress finally decided, after more than a century of starts and stops and repeals and human suffering, that permanent bankruptcy protection was a necessity, not a luxury. So what are we really talking about here? We're talking about the fact that for most of American history, failure was treated as a moral failing deserving of punishment. That ordinary people, farmers, merchants, laborers, even founding fathers, could have their lives destroyed, their freedom taken, their bodies branded because they fell behind on a payment. That the wealthiest nation in the world, a country built on risk-taking and entrepreneurship, had no permanent mechanism for managing the inevitable downside of that risk for over a century after its founding, and that it took repeated economic catastrophes, decades of human suffering, and the near collapse of the entire financial system for Congress to finally do what the Constitution had authorized them to do from the very beginning. And here's the final twist in this story. The pattern of American bankruptcy law, where each law was passed in response to a crisis and then repealed once things got better, tells you something profound about how societies deal with systemic problems. It's only when the pain becomes unbearable that meaningful change happens. The 1800 law came after the panics of the 1790s. The 1841 law came after the panic of 1837. The 1867 law came after the Civil War. And the permanent 1898 law came after the panic of 1893, the worst depression in American history to that date. Each time, Congress acted only because the suffering was too great to ignore. And each of the first three times, Congress repealed the law as soon as the crisis passed, reverting to a system that protected creditors at the expense of everyone else. It took 4 attempts and over a century of pain to get it right. The next time you hear someone casually mention filing for bankruptcy, or you see a headline about a corporation restructuring its debts under Chapter 11, remember what came before. Remember the debtors' prisons. Remember the brandings. Remember Robert Morris, the man who bankrolled a revolution and died forgotten in a Philadelphia row house because his country had no way to help him start over. The right to fail and recover isn't just a legal concept. It's one of the pillars that holds up the entire American economic experiment. And it took an astonishingly long time and an astonishing amount of pain for this country to figure that out. If this story of the struggle for financial second chances changed the way you look at the history of American law, please subscribe to our channel and like this video. We are dedicated to unearthing the historical truths that have been buried by time. Help us plant the seeds for a better understanding of our past. Our next historical investigation will be released very soon. Stay tuned.